This is Bloomberg Law with June Grasso from Bloomberg Radio.
Adherence to the rule of law is a bedrock principle of the Department of Justice, and our nation's commitment to the rule of law sets an example for the world. We have one set of laws in this country, and they apply to everyone.
In announcing one of the two federal criminal cases against Donald Trump, Special Counsel Jack Smith said that no one is above the law. It applies equally to everyone. However, the former president is claiming the law doesn't apply to him. Trump says he's entitled to absolute presidential immunity against criminal charges over his efforts to overturn the 2020 presidential election. So the special counsel is attempting to do an end run around the D.C. appellate court by asking the Supreme Court to step in to decide the issue in an effort to prevent a delay of the trial scheduled to start on March 4th. My guest is Derek Muller, a professor at Notre Dame Law School. Derek, tell us a little about Trump's claims of immunity.
So there are a couple of immunity claims that are happening. One, probably the weaker one, in my judgment at least, is that he was acquitted of certain things in his second impeachment trial. And as a result, that acquittal should function as a kind of immunity from prosecution. Now, again, it seems to me that there's a difference between impeachment and other kinds of criminal penalties, but it's at least an argument that's been raised. And the other, the more probably material one, the one that's getting more attention, is to think about, immunity from your actions as president. That is, you are engaged in your official capacity, you are engaged in executive functions, and the notion that you can be criminally prosecuted for that behavior, for the things that you're doing while you're conducting your job, you should be exempt from criminal prosecution as a result. And again, a lot of this turns on, well, at what point does your behavior sort of flip from official executive behavior to unofficial behavior, or political or individual behavior? Is there an immunity for crimes committed if you're purporting to do them in your official capacity? How could that possibly be the case, and so on? So that's kind of the heart of these immunity claims that are arising here.
The special counsel is asking the Supreme Court to step in using certiorari before judgment, which is essentially skipping the appellate court. It's unusual, but how unusual is it for the court to grant that kind of review?
Pretty unusual. So I think you can think about this as some layers. If you're asking the Supreme Court to have a petition for certiorari before judgment, sometimes that might arise if there's just a sort of preliminary injunction or preliminary posture of the case where maybe you want the court to step in. And so that happens. It's not common, but it's not uncommon. It's a relatively infrequent occurrence for the court to step in. But to sort of ask them to skip the Court of Appeals and go straight to the United States Supreme Court to resolve this matter before the D.C. Circuit has weighed in is more unusual. Now, on the one hand, you could say, well, I think this is a matter of presidential executive power. This happened in some of the cases involving Richard Nixon, if we're dealing with executive power and criminal investigations and so on. And these are major issues that we expect the Supreme Court is going to have to weigh in on at some point. So there's this notion up front that they'll weigh in, and so maybe we should just skip that step and get the United States Supreme Court involved if it's extraordinary, true, but these are extraordinary circumstances. On the other hand, you have to think from the justices' perspective about their willingness to sort of step in here and say, well, can we just let the process play out? Maybe if the D.C. Circuit does a good job, we don't really have to weigh in. We can just kind of agree with what they've said and just, passively let the case kind of continue below without us having to weigh in. So there's just some questions about what the court might do. But again, it's understandable why the prosecution wants to move this as quickly as possible.
Yeah. So, is that the real heart of the prosecution's claim, that they don't want to delay the March 4th trial date? And then does it become political because, trials are delayed all the time. Right. But if it's delayed in this case and he wins the presidency, then it'll never happen.
Yeah, I think when you're thinking about the strategy here, a cynical reason, and I don't think this is the reason, but a cynical reason is, well, I think I'm going to lose at the D.C. Circuit, so I want the Supreme Court to weigh in right away anyway. And I don't think that's right. I think the concern is if we have to go through a level of briefing, an oral argument, and waiting for an opinion at the D.C. Circuit, and then wait for another round of appeals to the United States Supreme Court and do the same thing all over again, which we feel like is inevitable, that can really start to press upon that March 4th date. And so there is this effort to move things along as quickly as possible. And yeah, I think you're right that we have this concern, if you're the prosecutor, that if there's any delay, this thing gets pushed back, and then there's all kinds of additional complexities. What happens if he's the nominee for the party? Can we realistically expect him to be facing criminal charges or sitting in a courtroom while he's supposed to be campaigning for president? That raises all kinds of unique and additional questions that have to happen. So we want this to be resolved as early as possible. If he's guilty, something the voters ought to know. If it's not guilty, also something the voters want to know. So there is this effort to resolve as early as possible. But there's no question it has some political valence to it. There's some political charge because whenever you're dealing with the front-running candidate for a presidential nomination for a major political party, whatever you do in any direction is going to have some kind of political ramifications and definitely some risks that we're going to see play out about how we balance those things.
And it was a different court, but you mentioned U.S. v. Nixon in 1974. In that case, I believe it was 61 days from start to finish.
Yeah, so we can move things quickly. There's no question that we can move things quickly in these processes. For the United States Supreme Court, I think about Bush v. Gore, where they granted cert on December 9th, oral argument December 11th, decision December 12th. That's record pace to move it in 3 days, right? But it's hard. These are hard issues. For the D.C. Circuit, they've recently been asked to handle a variety of hard issues with a gag order placed on former President Trump, on some other issues relating to charges and conduct. And, the courts have come to some consensus and opinions, and they've written things, but it's taken them a few weeks, and they're long opinions, and sometimes some judges write separately. So there's just a lot of things that have to be weighed here when you're looking at that March 4th deadline. And so it's understandable why you'd want to skip the D.C. Circuit, go straight to the United States Supreme Court, and to give them more time, right? Because if you're saying inaction is a form of action, right? If you are failing to act in a timely manner, you are effectively allowing the trial date to be pushed back. The court, I think, is going to have to weigh that very seriously and decide, if we take this case, we can have a couple of months for review rather than just maybe a couple of weeks, which seems less than ideal.
And the appeals court is going on a separate track where the special counsel is also asking for expedited appeal?
Yeah, so I think Special Counsel will seek expedited review in the D.C. Circuit. I don't think there's a scheduling order out there yet, although I'm sure that will come out in the near future. But even then, if you try an expedited briefing schedule, you then have to schedule oral argument. And while you have that as a firm date, you don't know how long it will take after oral argument to issue a decision. There's no formal timeline on that. You can say that you'd like it as quickly as possible, and the D.C. Circuit can try, but it might take a couple of weeks even working under the fastest of circumstances. So just looking at where we are in the calendar, it's mid-December. If you try to move as quickly as possible and try to get an oral argument by the beginning of January and a couple weeks for an opinion, it might not be teed up for Supreme Court review until mid to late January. And again, if you're looking at a March 4th trial date, that adds a tremendous amount of uncertainty and tremendous pressure on the Supreme Court to weigh in, again, on a truncated timeline. So, again, it's the reason why I say it's an extraordinary request from Smith's team here to seek the Supreme Court review, but totally understandable when you're looking at the calendar and what it looks like, and that this is a major sort of barrier to getting to that judgment. And if Trump is immune, the case goes away. And if he's not, then probably his strongest defense is gone, and we're going to a jury trial.
Normally, a respondent gets a month to file a brief opposing an appeal. But on Monday, the Supreme Court agreed to speed up the part of the process where it decides whether to take the case. It's only giving Trump until December 20th to respond to the special counsel's request. Does that indicate that the justices are aware of the seriousness of the case, or that they're inclined to grant the special counsel's request? Does it indicate anything at all?
So I don't know if they're inclined to grant, but I think it certainly means they are not disinclined. This is a small but important victory for Smith's team here, because if the court just says, no, we're just going to give you a month to respond, well, that pretty much settles it, right? It pretty much makes the decision for you. But by allowing expedited, response to the petition for writ of certiorari, it keeps all of the court's options open, right? Whether to grant and then have it on an expedited basis or to deny, send it back to the D.C. Circuit, allow it to proceed on the normal track. So this was sort of a necessary win for Smith's team, but it certainly, I don't think, suggests a whole lot about the merits, except that the court is kind of keeping its options open.
Coming up next, if the justices do take the case, how might they rule? I'm June Grasso, and you're listening to Bloomberg. Special Counsel Jack Smith is asking the Supreme Court to decide if Donald Trump is entitled to absolute presidential immunity against criminal charges over his efforts to overturn the 2020 presidential election. I've been talking to Notre Dame Law School professor Derek Muller. This would be a landmark decision, right? Whether a former president can be prosecuted for actions taken while in office. There's never been a case like this.
That's right. So no former president has been prosecuted, for crimes whether that arose during or after he took office. We can think about Nixon, the fact that President Gerald Ford sort of indicated he would grant a pardon for former President Nixon to sort of close the book on those cases, at least at the federal level, meant that it was turning the page, whatever metaphor you want to use to say that we're moving on from this. So that was probably the most sort of notorious example we can think about. But we haven't seen that with other presidents who have left office. So this question remains an open one. For former President Clinton, when he was in office, he was sued in a civil case, and the United States Supreme Court allowed him to be sued for that. And certainly it was not official conduct he was being accused of. It was personal conduct. So we have, a couple things that we're looking at historically, but really nothing on point. And yes, it would be a landmark decision for the Supreme Court here to weigh in and talk about the scope of presidential immunity to be exempt from criminal prosecution upon leaving office.
Tell us about the arguments from Trump and the special counsel.
The president's argument is essentially that the conduct he engaged in, whether it was trying to investigate voter fraud or trying to make claims that there were fraud or trying to exert pressure on members of Congress or Vice President Mike Pence in the Electoral Count Act or whatever it might be, that these kinds of behavior were executive functions. They were sort of presidential actions related to the ability to uphold the law. They related to his ability to sort of handle the oath of office and to uphold the Constitution, and as a result, whatever he did sort of exempt for prosecution. Whereas the special counsel side is to say, look, these are criminal actions. They sort of fall outside of the scope of any sort of immunity. There's nothing here that we could say is actually protected by the Constitution or protected by the official responsibilities. They're criminal actions, and at that point, they sort of fall outside of what we would otherwise call ordinary executive behavior. And then additionally, the question about whether or not his acquittal during impeachment exempts him now, saying that Congress has essentially said, no, he cannot be blamed or has no blame for these crimes and misdemeanors that he was accused of, whereas the special counsel is to say, look, that's the impeachment proceeding. Impeachment proceedings are political processes, even though they look like a trial process. They're very different. They don't exempt him from the criminal process. It's a very different question. And so there's no basis to say that acquittal and impeachment is a basis to immunize him from future prosecution.
The trial judge, Tanya Chutkan, of course, refused to toss out the indictment against Trump on grounds of presidential immunity, saying whatever immunities a sitting president may enjoy, the United States has only one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. Did you think that her decision was well-reasoned?
Yeah, I think one of the things we've seen, with her opinions in particular, is that they've been affirmed by the D.C. Circuit, although maybe tailored a little bit. So her gag order was affirmed by the D.C. Circuit, but the D.C. Circuit said, well, we want to tailor it a little bit and make sure that we're protective of First Amendment speech. And likewise, it definitely felt like the judge recognized, criminal conduct is not going to be protected by executive action. Now, again, there's a little bit of a play there because you're trying to figure out what is criminal action in the first place, or what did you believe or engage in. So it felt like it was was a careful and well-reasoned opinion. Now, there are probably places where scholars who have studied this area extraordinarily closely might pick at some areas in the way she set the test, and I'm sure to the extent the D.C. Circuit or the Supreme Court gets to consider it, I'm sure there will be some picking at the test, however it reaches a decision. But on the whole, I think the sentiment of the opinion was largely one that is likely to be affirmed, again, substantially, maybe not entirely, but substantially on appeal.
The Supreme Court has a 6-3 conservative majority, but since Trump left office, the court has not looked upon him favorably in the cases he's brought. I mean, does a conservative majority lean toward no presidents above the law, or does it lean in another direction?
I mean, I think whenever you're a justice in the court, and again, this is a benefit of being insulated from removal, barring impeachment or something like that. The ability that you have your job for a life allows justices to sort of think a little bit more dispassionately about these issues and realizing whatever you do here, just like whatever happened with cases involving Bill Clinton, whatever cases were involving Richard Nixon, you realize that you are setting major precedents for presidential power, executive authority, immunities, whatever they look like, not just for Donald Trump, but also for Joe Biden, whoever the next president is, right? So there is, I think, this institutional concern from the court, and it's a major question, right? We want to make sure that whatever we articulate about when former presidents can be prosecuted, again, the fact that it's happened for the first time doesn't mean it's not going to happen again in the very near future. Right? Once we've established that precedent, it's going to have a lot of sway in the future for potentially a lot of other cases. Maybe it's Republicans, maybe it's Democrats. So I think the court's view, regardless of whether you're a conservative or a more liberal justice, is going to be thinking about these issues from other kinds of hallmarks of executive power and what kinds of behavior or conduct in office immunize you from future prosecutions, where that immunity attaches and arises and where it doesn't. I think there was recognition, again, in the Clinton case, that certain actions are official behaviors and others are not. In another one of the cases in front of the D.C. Circuit, they were talking about how certain things of the president are official actions and other things are political behaviors when you're on the campaign trail, right? There are things that are in your candidate or individual capacity. So if that's the case, if there are these sort of lines to be drawn that are context-specific, the court has to be very careful about whatever they do, whatever they come up with, and make sure that it's something that can be readily administrable in the future so that it doesn't have to revisit these cases, the next time that a president faces similar things, which we hope doesn't happen, but it wants to anticipate and know what might be coming down the road.
Is this in any way a risk for the special counsel asking for this?
So I don't think it's a very big risk. I think the worst thing that can happen is the Supreme Court says no, goes back to the D.C. Circuit, proceeds as usual, and maybe he's not able to meet the March 4th deadline, right? But, I think the request is not one that seems overreaching. Again, just the fact that it's extraordinary. He's got extraordinary facts on his side. So he's got that, and it's sort of the discretion of the court to decide whether or not to grant it. So it is extraordinary, but it's not abusive, right? And it doesn't feel like entitlement. It's not just Jackson. It's Michael Dreeben, former Department of Justice official there, who has a lot of experience in front of the Supreme Court. So it carries some weight when you're thinking about this being filed in front of the Supreme Court. So it's not something that strikes me as egregious or outlandish that would somehow turn the justices against the special prosecutor in future appeals. It just strikes me as a serious and weighty request, one, again, that I think is a longer shot, but certainly not impossible. And even if it's rejected, I don't think there's any sort of negative fallout for the prosecutor's team here.
We keep saying unprecedented in so many of these cases involving Trump.
I think we are just in uncharted territory, as we are with many questions involving former President Trump, these criminal cases that are percolating in federal and state courts around the country, and a 2024 presidential campaign that is now hitting full swing. It's a lot of complicated factors that we are facing in the year ahead. Thanks
so much for sharing your insights with us, Derek. That's Derek Muller, a professor at Notre Dame Law School. Coming up next on the Bloomberg Law Show, just what is a clean beauty product and why are consumers suing over them?
Hey everyone, it's Helen, and I'm here with my beautiful model, Lucy. And today we're creating an everyday makeup look using all clean at Sephora products. And I think you're going to be just blown away by how simple this was to achieve.
I'm Aisha.
And I'm Melinda.
And today we're going to be talking about 5 clean beauty brands you need to know. Hi, I'm Tennille, and today I'm going to share with you some of my top picks from my lipstick wardrobe, and they're all clean. Okay, so first up in my clean beauty lip wardrobe is Tower 28 Slip Jelly.
Sephora is just one of the companies promoting clean beauty products. How much does that matter to consumers like climate-conscious Gen Zers and millennials? Well, the clean beauty market has grown from its roots in luxury and independent brands to take over shelves at mass-market retailers like Target, and it's forecast to expand to $15.3 billion by 2028. But just what is a clean beauty product? That's the question that's driving consumer-led class actions against Sephora and Target and raising the legal risk for companies trying to capitalize on the demand for clean beauty. Joining me is Shawn Collins, an attorney at Stradling. He advises companies on consumer litigation. What is a clean beauty product? Are there any parameters the public can rely on?
No, there aren't. And that's probably the most frustrating part about it. And this is not abnormal. I mean, the FTC and the regulatory bodies are always 5 to 10 years behind where the marketplace is. But, that is everybody's great frustration, is that there is no legal definition for beauty. And so what the FTC does in the absence of Congress, which is the body that is responsible for coming up with the definition of what beauty is, in the absence of Congress making a decision or passing a law that says this is how we're going to define a clean beauty product, the FTC releases what they call guidelines. So you'll see if you Google it, FTC guidance on everything will come up. FTC guidance on what it means to have a free product. FTC guidance on what it means to have a clean beauty product. And that guidance is not law. What they are trying to do is they are trying to create guardrails or boundaries that kind of give guidance to the skincare and beauty product lines out there in the world so that they at least have an idea of what is permissible and what's not permissible. But it's not very helpful because if you're a skincare or cosmetics company and you're kind of flying blind, you're just really kind of crossing your fingers and hoping that you don't do anything that will get the FTC's attention or maybe a state attorney general's attention.
There are now consumer-led class action lawsuits. Tell us a little bit about the lawsuit against Sephora.
The reality of the lawsuit against Sephora, and the reason why you're seeing so many plaintiffs' attorneys go after them, is it's like anything in life. Tall trees attract the most wind. Mm-hmm. So Sephora is one of the most recognized beauty and skincare companies in the world. You walk into any mall and even online, they have a huge e-commerce presence. It's one of the things that come to mind when, you ask a consumer, what do you think of when you think of beauty products? There's going to be certain brands that come to mind, L'Oreal, Sephora, etc. And so plaintiffs' attorneys know that, and they focus a lot on the clean beauty claims that Sephora is making. I guarantee you Sephora has very competent, very capable attorneys that are working for them, and they're probably working with outside counsel as well to say, hey, what can or can we not say? What can we put on our labels to try to capitalize on consumers' demand for clean beauty products? And what they're doing is they're reading the FTC guidance and saying the FTC says we can do this. But like I say, the FTC guidance is not law. And so, I feel bad for the companies because the companies I know are spending lots of money in making a concerted effort to comply with what we all think the definition of a clean beauty product is. And so to answer your question directly with this Sephora lawsuit, plaintiffs' attorneys are coming after them and saying, this is what the FTC guidance says, and you didn't do that. Therefore, you're in violation of the law. Now, what is the law? The law is Section 5 of the FTC Act, which is very broad and vague and amorphous. It says you cannot advertise a product in an unfair, deceptive, or misleading manner. And so the question becomes, well, what does that mean? What is unfair? What is deceptive? What is misleading? The FTC views it as, well, if a consumer is looking at your label and they don't quite understand what you're saying to them on that label, that's unfair, deceptive, and misleading. And plaintiffs' attorneys are bringing these lawsuits. What they're probably doing is they're probably going online and looking at the BBB complaints, Better Business Bureau complaints. And so if they see a consumer complaining about, well, I bought a product from Sephora and they said it's 100% natural or it's clean, They're saying, well, I looked at it and there's this ingredient that's prohibited in the state of California, therefore it's not clean. That's kind of the impetus for these lawsuits like the one you're seeing against Sephora.
What I was wondering is the Sephora lawsuit alleges that the ingredients in its clean products don't match up with consumer expectations. So who or what is going to determine what consumer expectations are? Polling?
That's a great question, and that's exactly what I'm talking about. That's what these plaintiffs' attorneys do. They say, well, the ingredients that you actually listed on your product don't match up with consumers' expectations. So the question becomes, well, what consumer are we talking about? Now, the law, this is one area where there is crystal clear law, so there's law on the books. The law says that it's the reasonable consumer. So then that begs the question of, well, who's the reasonable consumer? Is Shawn the reasonable consumer? Is June the reasonable consumer? We don't know. The reasonable consumer, I always tell my clients in an abundance of caution, is the lowest common denominator. So I tell my clients, when you are putting together your advertising, your marketing, or if you are labeling a product as a clean, all-natural beauty product, you have to assume that you are dealing with the 95-year-old grandma whose eyes are failing her. Like, I say that, and like my clients always laugh, and look, I am saying it in jest to a certain extent, but I'm being 100% honest with them, because the reality of the world we live in is there's always a plaintiff's attorney out there that's looking to make a buck, and if they find 95-year-old grandma that has bad eyesight, they're going to say, well, I bet there's about 100 or more other grandmas just like her out there. And that's the consumer that you should have been thinking about when you put that label together, and you misled them. Therefore, I'm bringing this lawsuit. Again, I think that's incredibly unfair. I actually think those types of lawsuits hurt the consumer more than help the consumer. What it does is it lines the pockets of plaintiffs' attorneys to the detriment of the consumer. So it's very frustrating for me, but that's unfortunately the world that we live in right now.
So explain what you tell your clients about, where to put the claims like clean and the font.
So I always tell my clients that, especially if you're going to make that word clean or all natural, if you're going to make it very bold and prominent, which, look, that's what everybody wants to do right now because the market research demands that. Let's not kid ourselves. The clean beauty products industry is a multi-billion-dollar industry right now and growing. Because what market research suggests is, especially younger folks, so you're talking about the Gen Zs, I'd say millennials as well, but even younger than that, Gen Zs, 18 to 28, they really care about whether or not their products are ethically sourced. They care about the environment. My 10-year-old son's always talking about the environment, making sure we're taking good care of the earth, which I love, but extrapolate that into their consumption. They want to see that the products that they're associating themselves with also care about the environment. Companies realize that, and that's why it's become such a big deal to put the word clean or all natural on your product. So that being said, with that mindset, I always convey to my clients that the reality of the situation is that one of the things that's most likely to make a young person, an 18 to 38-year-old person, pick up your product is whether or not it's a clean or all natural product. And so clearly you want to promote that on your product. So I tell them, absolutely, you can put the word clean or all natural, but if especially here in California, so California is probably the most aggressive when it comes to consumer protection. California has a long list of products. We have Prop 65, where you have to give warnings if you have certain products or certain chemicals or ingredients in your product. So in a state like California, which is a very big marketplace, we got 39 million people that live in the state of California. We're the fourth largest economy in the world if we were a country. Clearly, if you are a company, you want to advertise your products in this state. It's a very big marketplace. I tell my clients, if you're advertising here in California and you're going to use that word clean or all natural, and you know that there might be an ingredient or more that could potentially not be classified as clean or all natural by the California Attorney General, you need to do one or two things. You either need to hedge with your language, meaning most people like to say 100% natural. I always tell them, well, if it's not 100% natural, you could say mostly natural or, something to that effect. And obviously, the clients don't like that, especially the advertising department, because they're like, no, we want to use all natural. And I say, look, I'm not going to tell you that you can't use all natural, but if you don't put an asterisk next to it or soften that language a little bit, there is the potential that a plaintiff attorney could come after you.
Do these suits resemble the greenwashing suits? Is there anything that can be learned from those suits?
Yes, they absolutely resemble the greenwashing suits. I mean, they're pretty much one and the same. It's just that the clean beauty ones are obviously more focused on the skincare and aesthetics industry. They're more focused on that in particular, but they're pretty much the same. They're insinuating that a company is trying to capitalize on the consumer's concern. So in the context of greenwashing, they're basically saying, you as a company are trying to capitalize on the consumer's concern about ESG. You recognize that the marketplace and the consumers in the marketplace are very worried about the environment, sustainability, et cetera, and you are trying to advertise your product in a manner whereby you are trying to align yourself with the ESG movement. So pivot over to the skincare or the aesthetics world. They're saying you as a skincare company are trying to align yourself with the clean beauty movement, and you are, this is what the FTC would say, you are misrepresenting the cleanliness or the all-naturalness of your product for purposes of trying to capitalize on this multi-billion-dollar industry.
I mean, do you think that these are lawsuits that are going to get thrown out at the motion to dismiss stage?
Yes, I do. And that's the frustrating part is, if you're a company, there's certain companies that are startup. I have 2 or 3 clients that they're a 1 or 2 man shop, and they're like, you know what? I wanted to create a skincare product that spoke to me and who I am, and I created this product, and now they're getting hit with these lawsuits. And look, it's not cheap to defend against the motion to dismiss, and plaintiffs' attorneys know that. I call these lawsuits shakedowns because that's effectively what they are. They recognize that if I file this lawsuit in California, if I bring this CLRA claim, if I bring this UCL claim or this false advertising law claim, this 1 man or 2 man show, they don't have the money to pay Shawn or Stradling, Yaka, Carlson, and Ralph $20,000 to file a motion to dismiss. So I'll just basically tell them, settle with me for $10,000 or $15,000, and we'll call it a day. And look, the reality of it is for my clients where they're the 1 or 2 man shop, that's a good business decision. If they can get out of it for $5,000 or $10,000 and not have to pay me $20,000 to file a motion to dismiss, that's a good business decision for them. Now, for my larger clients who have the resources, we absolutely fight these because, like I say, they're shakedown. And so, I don't want to toot my own horn, but me and my team, we have a great record of killing these on motion to dismiss. For all the reasons that I've stated earlier, these lawsuits are being brought based on, well, hey, you didn't do what the FTC said in their guidance. And obviously the crux of our motion to dismiss is that's guidance. That's not law. And, we were very diligent and made a beyond good faith effort to comply with the FTC's guidance. Therefore, we are not in violation of the law, and we're moving to dismiss all of your claims.
Some companies are taking the initiative in telling their customers what clean means. So Goop did it. Does that save them from lawsuits if they say, this is what clean means to us?
You know what? It does, and I love that. And I think that everything that Goop is doing is phenomenal because they're being proactive. So in the absence of the federal government stepping up and saying, this is the law, this is what the standard is, the marketplace effectively has to create the standard. So keep in mind, like I said earlier, the reasonable consumer can be anything. It's kind of amorphous. And so if a company comes out and says, you know what, the federal government hasn't created a standard, they haven't created guidance, but this is our standard. What they're saying is when I say clean, this is what I mean. So before you purchase my product, consumer, understand that this is what I mean when I put the word clean on it. And if you don't agree with my definition, it's your choice whether or not you want to buy this product or not. I love that. I think Goop and the other companies that are doing that are doing a phenomenal job. And that's exactly what I recommend to all of my clients.
What about a disclaimer?
So disclaimers are good. Disclaimers are good. The one caveat I would say about a disclaimer, one thing I've been talking quite a bit about, what the law says and the guidance. So I talked about the reasonable consumer. Another bright line rule in the advertising and marketing world is that when you are making claims in connection with your product, especially if it's a material claim, so a material claim meaning this claim is likely to lead to the consumer purchasing my product. So clearly, in this context, the word clean or all natural would be a material term. If you are going to use those types of terms, you need to make that the disclosure in what they call a clear and conspicuous manner. That is the standard, meaning it has to be so prominent for the consumer that they can't miss it. So to answer your question, if you're going to give a disclaimer, you heard me say asterisk earlier. So a lot of the times if a customer has like a product label on a small bottle or container and you don't have a lot of space to work with, you can put an asterisk next to the word clean, meaning this asterisk is the universal language, but there's a disclaimer connected with this word clean. So if you're going to put that disclaimer on there, it also has to be displayed prominently, meaning the consumer doesn't have to go looking for it. So what I recommend to the client is if you're going to put a disclaimer or if you're going to have an asterisk, it needs to be in close proximity to the word clean. That usually means within the line of sight. So if I'm looking at a product label or a container and I see the word clean, I shouldn't have to turn the product over to read the disclaimer. I shouldn't have to turn the product to its backside, or I shouldn't have to open the box to read the disclaimer. The disclaimer should be right there in the line of sight with the word clean or with the words all natural.
Do you expect more of these consumer class action lawsuits?
This is going to grow as the market for clean beauty products grows. And like I say, right now it's a multi-billion-dollar industry and growing. The last numbers I read, the addressable market for clean beauty is in the $2 to $5 billion range, and it could go upwards to $20 billion or more. Because, like I say, the younger generation, it's what they care about. They're very, 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 very concerned about aligning themselves with products that are ethically sourced. And companies know that, and they want to capitalize on that market. And because companies are trying to capitalize on that marketplace, plaintiffs' attorneys and regulators are paying close attention. My thought is that follow the guidance of, do exactly what the Goops of the world are doing. I think what they're doing is phenomenal. In the absence of the federal government stepping up and saying, this is what clean means, create your own definition and make consumers aware of it so that when they come back and say, I didn't know that you had this in your product, you can say, hey, I disclosed to you before you purchased my product that this is how I'm defining clean, and I gave you fair warning and notice that this is my definition. And then you had the choice to decide whether or not you wanted to align yourself with my product.
Thanks so much for being on the show, Shawn. That's Shawn Collins, a shareholder at Stradling. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.